Good afternoon, everyone. My name is Teresa Chong, and I'm an attorney with the Center for Families, Children, and the Courts at the Judicial Council of California. And with me today, co-presenting, I have my colleague Ann Hedrius, who is a supervising attorney also with CFCC at the Judicial Council. And we are here to provide an extensive overview of the judicial process for the CARE Act. So here we have the agenda for today. We'll be discussing the role of the Judicial Council, an overview of the CARE Act process, general provisions, how to initiate a case, the different hearings that can occur, accountability roles, additional factors counsel should consider or note during the CARE process. I just wanted to also note that you may notice some red asterisks on some of the slides, and these are to note the changes and updates to the CARE Act per Senate Bill 35, which we believe will be sent today or sometime this week. But we wanted to include those updates in today's presentation. So before we dive into the CARE Act, we wanted to start with introducing what the role of the Judicial Council is for those who are not familiar. The Judicial Council's role is to support the integrity and independence of the judicial branch and to seek to ensure that judicial procedures enhance efficiency and access to the courts. Also, the role of the council is to improve the administration of justice by adopting rules for court administration and procedure that are not inconsistent with statute. We also wanted to note that rules adopted cannot enact substantive policy changes. That requires the legislative action and approval by the governor. So the CARE Act requires the Judicial Council to adopt a mandatory petition form, as well as any other forms necessary for the CARE process. The Act also requires the creation of rules of court to implement the policies and provisions of Welfare and Institutions Code sections 5977 to 5977.4 to promote statewide consistency, including documents to be included in the petition form packet, the clerk's review of the petition, the process by which counsel can be appointed, and communications between the CARE Act and juvenile court. So here are some of the asterisks that I mentioned before, and these are the updates per SB 35. Okay, so in response to the CARE Act requirements, the Judicial Council has done the following. It has created 11 new rules of court, which include preliminary provisions, commencement of proceeding provisions, notice and joinder, and accountability provisions. The Judicial Council has also developed 13 new forms, encompassing 8 mandatory forms and 5 optional forms. And the next slide includes a list of all of the mandatory forms. There are 2 initial filing forms, the petition CARE 100 and the mental health declaration CARE 101, and those are required to initiate the CARE process. There are 4 notice forms listed here, as well as 2 informational forms for respondents that include information about the process and the respondents' rights throughout the process. So here we wanted to provide a snapshot and flowchart of the CARE Act process. Some of you may be familiar with this chart already. The flowchart includes the initiation of the cases, as well as the different proceedings and outcomes that can occur during the process. So as you can see, the CARE process involves a number of assessments and hearings to determine whether the respondent meets CARE eligibility requirements. Here we want to provide some general provisions regarding the CARE Act process, and we're starting with confidentiality provisions. So the CARE Act proceedings are presumptively closed to the public. However, the respondent may demand that a hearing be public and held in a place suitable for public attendance. Also, the respondent may request the presence of any family member or friend without waiving the right to keep the hearing closed to the rest of the public. However, a request to make the hearing public by any other party may be granted if the presiding judicial officer finds that the public interest in an open hearing clearly outweighs the respondent's interest in privacy. And lastly, all reports, evaluations, and diagnoses or other information filed with the court related to the respondent's health shall be confidential. And an update in SB 35 would also allow the respondent to petition the court to seal the records and create a presumption in favor of sealing. Records would also be inadmissible in other legal proceedings, except on motion by the respondent, county behavioral health agency, public guardian, or public conservator. Okay. Next, we wanted to touch upon the ability to access records. All documents filed and all evaluations, reports, and other documents submitted to the court in CARE Act proceedings are confidential. Only the following individuals may inspect the case records without a court order. And those individuals include the respondent and their counsel, the county behavioral health director or the director's designee and their counsel, and the respondent's supporter with the express consent of the respondent. So the next two slides discuss the service requirements for CARE Act proceedings, and we just wanted to highlight those. Per Rule of Court 7.2235, a notice of all CARE Act proceedings must be served personally on the respondent, or if personal service is not practicable, by any method reasonably calculated to give the respondent actual notice. Proof of service on the respondent by any method other than personal service must include an explanation of why personal service is impracticable and why the alternative method of service used is reasonably calculated to give the respondent actual notice. For all others who are entitled to be noticed, including the respondent's counsel, notice or other documents may be served in any of the following ways: personally, by first-class mail, express mail or overnight delivery, by fax, or electronically. And lastly, here we wanted to provide information about the respondent's rights throughout the CARE process. The CARE Act confers a number of rights to the respondent throughout the CARE process, and these rights are included on Form CARE 113, the Notice of Respondent's Rights. Form CARE 113 is a mandatory form, and notice to the respondent of each hearing must include Form CARE 113. And the next slide lists the respondent's rights, which are noted on Form CARE 113. The respondent has the right to be informed of CARE proceedings, to receive notice of each hearing, be present and personally participate at each hearing, be represented by counsel at all stages of the CARE process, regardless of their ability to pay. The respondent has a right to receive a copy of the petition and copies of any court-ordered evaluations and reports. The respondent also has the right to have a supporter be present with them and assist them through the process. They have the right to present evidence, call witnesses, cross-examine witnesses, and appeal decisions. Per SB 35, the respondent also has the right to an interpreter if necessary. And again, the respondent has the right to keep confidential all evaluations, reports, documents, and filings submitted to the court for the CARE Act proceedings. So now I will pass this on to Anne to start the discussion of the initiation of the CARE Act process.
Thanks, Teresa. Again, my name is Anne Hedrius, and I'm also an attorney here with the Judicial Council Center for Family, Children, and the Courts, and happy to try to walk you all through some of the steps, well, all of the steps of a CARE Act petition and CARE Act hearings. So we're going to start with the case initiation, and that's, as you can see here, that can be from a court referral, but all cases must start with a petition, and the petition must be on a CARE 100. So what is the petition? Statute calls it a petition packet. What does the petition packet have to include? It must include a Form CARE 100, and that's a mandatory form. There's some copies of the pages there. All of these forms are now available on the courts.ca.gov website. And then in addition to the CARE 100, it must include one of two things, either a CARE 101, which is a mental health declaration from a licensed mental health provider, discussing why they believe or have reason to believe that the respondent meets criteria, or evidence as described in Section Welfare and Institutions Code 5975 D2, which is evidence of 5250 holds, the most recent of which is within the last 60 days. And Just as a general note, we do have an optional information for petitioners form, CARE 050 info, which walks through how to fill out the petition. And we will have information on our website about that process as well. All right, where can it be filed? So 3 options within the statute and the rules of court. Can be filed either where the respondent resides, where they are found, and these are at the time of filing, or where they are a defendant or facing a pending criminal or civil action or proceeding. As we mentioned, the Act outlines that must be a rule regarding the clerk's process for reviewing the petition. And that rule is 7.2221B, which states that a clerk will take the petition, file it, assign a case number, and then place it in a confidential file. It's worth repeating, all documents filed in CARE Act proceedings are confidential, and confidential is included on all of the judicial counsel forms. So if the case has been filed in a county other than the county of the respondent's residence, the court should try to move it if CARE Act has started in their respondent's county, but only with the respondent's consent. Respondent does not consent, it will not be transferred. But the rules do set out the procedures for transferring the case from one county court to another. And that includes providing notice and a copy of the order to a variety of parties, the petitioner and their counsel, if they have any. A former petitioner, and we're going to get to in a little bit what happens when the court transfers petitioners. The respondent, their counsel, and if the respondent has provided express consent to their supporter. County Behavioral Health Agency, where it was filed, if they were not the petitioner. A county agency is preparing the report, to the extent they're not the County Behavioral Health Agency, and the County Behavioral Health Agency in the county of residence. And so to make sure that this goes through smoothly, if the court orders the case to be transferred to the county of residence, clerk from the transferring court will transmit to the clerk of the receiving court a certified copy of the order and all papers on file. Once they receive that file, they will send a written notification of receipt to the transferring court. And if for whatever reason the transferring court has not received a notification of receipt, it must make reasonable inquiry into the status of the transfer proceeding. All right, so there's a very specific group of people that can file a petition. Not everyone who might be interested can file a petition, and that list is included within the statute and there are boxes within the CARE 100, but the statute lines out 13 categories of individuals who can file. And then for cases where a court is referring, it all specifies who the petitioner will be in those cases. And that's noted here. So if it's transfer from an AOT case, the County Behavioral Health Director will be the petitioner. If it is an LPS conservatorship case, it'll be the conservator. And from misdemeanor incompetent to stand trial proceedings, and this is new per SB 35, it would again be the County Behavioral Health Director. And this is just a screenshot of the form itself. Petitioner must check at least one box. All right, respondent criteria. So respondent criteria is laid out in 5972. And I will say we also have a little video on this that we can provide to people about the qualifying criteria, but relatively quickly go through. Person must be an adult, 18 years or older. They must have a diagnosis within the disorder class of schizophrenia spectrum and other psychotic disorders, and that's a very specific list. And they must have a serious mental illness, which is defined as being severe in degree, persistent duration, such that it may cause behavioral functioning that interferes substantially with activities of daily living and may result in an inability to maintain stable adjustment and independent functioning without treatment, support, and rehabilitation for a long or indefinite period of time. And that's a little bit of a mouthful, but it's a very specific requirement. They must not be clinically stabilized in ongoing voluntary treatment. This wouldn't be the right program for them in that case. Next slide. A couple other requirements, and I think most people recognize these. Must either be unlikely to survive in the community without supervision and have a condition that's substantially deteriorating, or need services and supports to prevent a relapse or deterioration that would likely result in grave disability or serious harm to respondent or others. And lastly, a care plan or agreement must be the least restrictive alternative necessary and be likely to benefit the respondent. All right, and now we're going to go on to the next step in the process, and I'm going to send it back to Teresa.
Hello again. So here, I just wanted to remind everyone where we are at in the CARE Act process. So we're at the prima facie review after a petition has been filed. So when the court receives a petition, a prompt review will be made to determine if the petitioner has made a prima facie showing that the respondent is or may meet CARE criteria. If the court finds a prima facie showing has not been made that the respondent is or may meet CARE criteria, the court may dismiss the case without prejudice. If the court finds a prima facie showing has been made, different steps will be taken based on who the original petitioner is. So here, regardless of who the petitioner is, if the court finds that the petitioner has made a prima facie showing that the respondent is or may meet CARE criteria, the court must appoint counsel for the respondent. So the court will either appoint a qualified legal services project as counsel or appoint a public defender or an attorney acting in that capacity to represent the respondent if no qualified legal services project has agreed to accept appointments. From what I understand for cohort 1, San Francisco County will be appointing a qualified legal services project as counsel, while the other 7 counties will be appointing a public defender or an attorney acting in that capacity to represent respondents in their counties. So upon appointment, the court must provide a copy of the petition packet to appointed counsel. As noted previously, the respondent is entitled to be represented by counsel at all stages of CARE Act proceedings, regardless of the ability to pay. Okay, next slide. Okay, so here, after a petition has been reviewed, a prima facie determination has been made that the respondent meets or may meet CARE criteria. This is where the next steps taken differ depending on who the petitioner is. If the petitioner is the director of a county behavioral health agency or their designee, the court will set the matter for an initial appearance within 14 court days, determine if the petition includes the information noted in section 5977 of the Welfare and Institutions Code, or order the county to submit a report within 14 court days that includes that information. And that the information that should be in the report includes a determination as to whether the respondent meets or is likely to meet CARE criteria, the outcome of efforts made to voluntarily engage the respondent prior to the filing of the petition, and conclusions and recommendations about the respondent's ability to voluntarily engage in services. The court will also order the county behavioral health agency to provide notice of the hearing to the respondent and their appointed counsel. And this order must be made on Form CARE 105, order for the CARE Act report. So here, if the petitioner is a person other than the director of a county behavioral health agency or their designee, the court shall order a county agency or their designee to investigate and file a written report within 14 court days that includes the information noted in 5977 of the Welfare and Institutions Code. That report is similar to the information included is similar to the information I just noted. a determination as to whether the respondent meets or is likely to meet care criteria, the outcome of efforts made to voluntarily engage during the 14-day report period, and any conclusions and recommendations about the respondent's ability to voluntarily engage in services. Here, we wanted to note that if SB 35 is signed, the report should also include information, protected health information necessary to support the determinations, conclusions, and recommendations in the report. So next slide. So before engaging the respondent and preparing a report, the county agency ordered to do so must provide written notice to the respondent that a report has been ordered. So again, we wanted to note here, the respondent must be served personally or by any methods reasonably calculated to provide actual notice. The county agency must also give notice to the respondent's counsel and the petitioner, and notice must be given on the Notice of Order for Care Act report, Form Care 106, and it must include the following documents: a copy of Form Care 105, the Order for Care Act report that was issued by the court, a copy of the petition packet filed to begin the proceedings, and Form Care 60 information for respondents. I just want to note here, there is also optional Form Care 107, which is a proof of personal service of notice form for the Care Act report, which is an optional form that can be used to show proof of service. And here we wanted to note that the court will allow for additional time for a report to be made. If the court grants that additional time to engage with the respondent before filing the report, the county agency must, within 5 calendar days of the order, serve notice of the extended report deadline on the respondent, the respondent's counsel, and the petitioner. This notice must be given on Form Care 106, a notice of order for Care Act report. Upon receipt and review of the report, the court shall do one of the following within 5 days. So if the court finds the county's report does not support the petition's prima facie showing that the respondent meets care criteria, the court will dismiss the petition. If the court finds that voluntary engagement with the respondent is effective and that the individual has enrolled or is likely to enroll in voluntary behavioral health treatment, the court will dismiss the petition. If the court finds the county's report does support the petition's prima facie showing that the respondent meets or may meet care criteria and engagement was not effective, the court will set an initial appearance within 14 court days and order the county to provide notice of the hearing to the petitioner, the respondent, the appointed counsel, and the county behavioral health agency in the county where the respondent resides. I'll pass this off to Anne to discuss what happens at the initial appearance.
All right, so where are we at? So there's been a petition. His petition's met the prima facie determination. If necessary, there's been a county report. If the county does not believe the person meets criteria, or if they're willing to voluntarily engage and likely to agree to services, in all those cases, the case would be dismissed. But we're going to say for now that that hasn't happened. So we're going to go on to the initial appearance. All right, so what happens at the initial appearance? Just briefly, that there's very specific notice requirements. This is going to be the first time the respondent and the petitioner, the parties are going to be coming to court. And so we have an additional special form for notice of initial appearance that's included here, and it must be done on Care 110. And notice, and this will be true for all hearings, must be given at least 5 court days before the hearing to respondent, respondent's counsel, petitioner, petitioner's counsel, and the county behavioral health agency. So what needs to be included? Again, for respondent, it must be personal service unless that's not practicable. And in that case, by any method reasonably calculated to give the respondent actual notice. It must also include several things. It must include the petition packet, whatever was filed by the original petitioner, any report that was ordered, note the Care 113 that Teresa was talking about, which is the one-page notice of respondents' rights, and the Care 060, which is the longer information for respondents. And there is an optional personal proof of service form, Care 111, that can be used for the respondent. For the other parties, can be any of the array personally, first class mail, express mail, overnight delivery, fax, electronic. And to respondents' counsel, it must also include a copy of the petition packet if they haven't gotten it yet, and a copy of any report that's been ordered. And that applies to both the kinds of reports that happen before an initial appearance. So what happens at this initial appearance? A few things are going to happen. One, the respondent can substitute their counsel. They can decide they do not want the appointed counsel and substitute their own counsel, although in that case, they would be responsible for compensating their attorney if the attorney needs compensation. There is a rule regarding relieving appointed counsel, which can be done at the request of the respondent, or on substitution or for cause. A couple of other things, big things that must happen. So the petitioner shall be present. If they're not present, the case may be dismissed. Note it says may, not shall. If the petitioner is anyone other than the county behavioral health agency, the court will issue an order relieving what we're going to call the original petitioner and appointing the director of the county behavioral health agency as substitute petitioner. And I'm seeing Nina's question in the chat, and since it's timely, I may answer it. So the question is, if the respondent does not want their public defender, but does not have the ability to pay for private counsel, can they be pro per? And that's a good question. The guidance we've given is likely yes, but there's nothing specifically in the statute about it. But in other cases, individuals have been allowed to represent themselves. So that seems to be what people think is likely. All right, so relief. So if we had an original petitioner, what happens? Regardless of who it is, if it's not county behavioral health, they have a right to be, and this is slightly different language with SB 35, but general idea, if they would have a right to be present and to make a statement at the hearing on the merits, which we're going to get to in a few minutes. If they are one of the two first categories, so that's an individual who lives with the respondent or one of these family members, spouse, registered domestic partner, parent, sibling, child, grandparent, or someone standing in loco parentis of the respondent, they have the potential for ongoing rights, although it's not required. The court may assign them additional rights of notice, and they may be allowed to petition to participate in future proceedings, but only if the respondent consents. And lastly, they can file a new petition if there's a change in circumstances. And I think that's probably true for most people. Now we're at the hearing on the merits. So one quick note, the hearing on the merits, it can be heard concurrently with the initial appearance, but only if all parties agree. All right, so the hearing on the merits, we'll assume that it wasn't heard at the same time. So now we're going to have a separate hearing. And what's going to happen there? This is basically it's an evidentiary hearing at which the court, by the end of it, will make a determination about whether or not there's clear and convincing evidence that the respondent meets the criteria in 5972. And one thing to note for folks that also work on AOT cases, assisted outpatient treatment, this is different than those cases, and that those have a petition and everything's kind of within the petition. Here, the statute allows for whatever evidence the parties want to provide, in addition to that statement from the original petitioner, if there is one. but both parties can provide as much evidence as they want to, looking at the petition, looking at any orders and anything else beyond that. So at the end of it, the court's going to make this determination. If they find that there's not clear and convincing evidence, they will dismiss without prejudice unless they find that the filing was not in good faith. But if they do find there's clear and convincing evidence, they will do a couple of things. They will order the county behavioral health agency to work with the respondent, their counsel, and their supporter, if they have one, to attempt to engage them in behavioral health treatment and determine if they'll be able to enter into a care agreement. And they will set a case management hearing within 14 days. And note here, it's for some reason we switched from court days to regular days, so now it becomes calendar days. Next slide. So notice requirements, and this is true for all of the hearings after the initial appearance. Those have to be done on Care 115. And there is also an optional proof of personal service form, Care 116. And again, must be given at least 5 court days notice for the respondent's counsel, any local government entity that the court has joined. And we'll get to that in a minute. And the respondent supporter if the respondent has given express consent. And so the idea would be that the respondent would either say in open court that this person is this is my supporter and I want them to get access, or would do something in writing. And as I was saying, this is it. You're going to see this each time when we're talking about the respondent. It always must be personal service unless it's not practicable. The idea really was that these are important hearings, and some of the people receiving them may not have a fixed address, and so personal service is mandatory unless not practicable. And to be clear, it's the county that is required to be providing this service. And one question is Care 115 required if they're present? Yes, I mean, technically may seem like an unnecessary step, but according to the rules, it must be given that way. And for each hearing, a new copy of Form Care 113 must be included. For others, you have the array. Still have to use 115, but variety of options. Right, and then, all right, so we've had a hearing on the merits. There's clear and convincing evidence that the respondent meets criteria. Now we're going to come back within 14 days, and the court will look at whether the parties have entered a care agreement or are likely to enter a care agreement or not. And the SB 35 actually cleaned up this language a little bit to allow the court more explicitly to do a continuance here. But this is where we're going to kind of diverge in the paths of the legal process. So next slide. So if the court finds that the parties have entered, it can modify, it can either approve or modify and approve, and they will set for a progress hearing. And that's what we're going to call the care agreement route. If they have not come to agreement, and it looks like they're not going to come to agreement, there's no point in, putting it out for another week or so. The court will order the county behavioral health agency to conduct a clinical evaluation and set an evaluation hearing within 21 days. And Teresa's going to talk about the clinical evaluation hearing in a minute, but the county must file that evaluation with the court and with respondents' counsel no less than 5 days before the clinical evaluation hearing. So if they agree, parties come to an agreement, looks like everyone's happy with their care agreement. The court approves it. What happens? We go to a progress hearing. Next slide. We included this here because there's been a lot of kind of confusion around this piece, because there's very little guidance within the statute about what happens at a progress hearing and what really that means. And so what that leaves us for is a lot of discretion for the court, for the parties to decide what to do. So the statute only lays out required one progress hearing, but you can have more. And some courts, I think, will probably be doing it on a case-by-case basis of what makes sense. One thing that's kind of up in the air is whether folks on this care agreement path will go through the graduation. And that's kind of open as well. But that's something that I think the parties and counsel may want to think about what they think is best for their clients. So now we're going to go the other way on the chart and think about what happens if they do not agree. And Teresa's going to take it from there.
Hello again. So let's we're back at the care process chart. I'm going to refer to it to remind everyone where we're at. Clinical evaluation hearing. Again, this occurs if the court finds that the parties have not entered into a care agreement and are not likely to enter into one. And it occurs after a clinical evaluation has been ordered. So after the case management hearing. So here at the clinical evaluation hearing, the court will review the evaluation and any other evidence presented. And thereafter, the court will make a determination and do one of the following. If the court finds there's not clear and convincing evidence that the respondent meets care criteria, they'll dismiss the petition. If the court finds by clear and convincing evidence that the respondent does meet care criteria, the court will order the County Behavioral Health Agency and the respondent, along with the respondent's counsel and supporter, if any, to jointly develop a care plan within 14 days. The court will also set a care plan review hearing no more than 14 days of the order to develop the care plan. Go back to the flow chart here. So now we're at the care plan review hearing. So at the care plan reviewing, what happens? The parties present their care plans to the court. There can be one or a couple of care plans presented. The County Behavioral Health Agency, the respondent, or both may present a proposed care plan. After consideration, the court will adopt the elements of a care plan that support the recovery and stability of the respondent. In addition, the court may issue orders to support the respondent in accessing appropriate services, which include prioritization for those services and supports, and these orders will constitute the care plan. Furthermore, the court may order medication only if it finds by clear and convincing evidence that the respondent lacks the capacity to provide informed consent. If the court orders medically necessary stabilization medication, the medication cannot be forcibly administered, and failure to comply shall not result in a penalty to the respondent. So if the proposed care plan includes services and supports provided through another local government agency, that local entity may agree, or the court may consider a motion to add that local entity as a party to the care proceeding. So the issuance of an order approving a care plan begins the care process timeline, which shall not exceed 1 year. The court will also set a status review hearing within 60 days of the care plan review hearing, and order the County Behavioral Health Agency to follow with the court and serve on the respondent a report at least 5 days prior to the review hearing. Here, we just wanted to bring light to the joinder rules. Before granting a motion or request to join as a party another local government entity, the court must order that local government entity and all parties to show cause why the entity should not be joined as the party in order to provide the service or support, and set a hearing on the order to show cause no fewer than 15 calendar days after the date of the order's issuance. So we're back at the flow chart, show you where we're in the process now. We're at the status review hearings. So after the issuance of an order approving a care plan, the status review hearing will be set within 60 days. So let's see, so I've said this already, no less than 60 days. Status review hearings will be held. Again, at least 5 days prior. County Behavioral Health must file the report and serve the respondent, the respondent's counsel, supporter, if any, notice of the hearing, and copy of the report. At the status review hearings, the respondent is permitted to respond to the report and introduce their own information and recommendations. Okay, and here we just wanted to note that there can be additional hearings throughout this process. The county behavioral health and the respondent may request a hearing to address any change of circumstances at any time during the care process. And there is an optional form to use to request a new hearing, and that's form Care 120. Okay, hang in there. We're at the final stages of the care process. Here we're at the 1-year status hearing, where one of 3 things can occur. So here, the 1-year status hearing occurs at the 11th month of the program timeline. At least 5 court days before this hearing, the County Behavioral Health Agency must file a report with the court and serve the report on the respondent, respondent's counsel, and supporter, if any. The report must include the progress the respondent has made, including any final assessments of the respondent's stability, service and supports the care plan has provided, and those that were not provided. Any issues the respondent has expressed or exhibited in adhering to the plan, and any recommendations for next steps. So at the hearing, the respondent may voluntarily remain in the program. They may be involuntarily reappointed to the program, or they may choose to graduate from the program. So in the flow chart, we're going to go with the first thing that could happen at the 1-year status hearing, and that's if the respondent chooses to voluntarily remain in the care process. So if the respondent chooses to remain in the program, they may do so for up to 1 additional year. The court may permit ongoing participation if it finds the respondent did not successfully complete the care plan and the respondent would benefit from continuation of the plan. So the court will either issue an order permitting the respondent to continue or denying the respondent's request to remain, and state its reasons on the record. So the next step in the flow chart shows if the respondent is voluntarily reappointed to the program. So here, the respondent may be involuntarily reappointed to the program only if the court finds by clear and convincing evidence that all of the following conditions apply. That if the respondent did not successfully complete the care process, all services and supports required through the care process were provided to the respondent would benefit from continuation in the process, and the respondent currently meets the care eligibility requirements. So a respondent may only be reappointed to the care process once for up to 1 additional year. And now I'm going to pass this back to Anne to discuss what happens in the event that the respondent chooses to graduate from the program.
All right, so option 3 after 1 year is the respondent chooses to graduate. And then we go to a graduation hearing. The court will order the County Behavioral Health and the respondent to work jointly on a graduation plan. So this is something to set them up for services after care. And we'll schedule a hearing in the 12th month after adoption of the care plan to present that plan to the court. At that time, there'll be a review of the graduation plan. The terms of the plan will be recited in open court. A couple of restrictions on the graduation plan: it cannot place any additional requirements on local government agencies, and it is not enforceable in court. So the respondent could not sue to have it enforced. It may, if the respondent wants, include an advance directive. And there are a range of trainings on psychiatric advance directives, can certainly connect people to, but that's one thing that will be considered at the graduation. Upon completion of the hearing, the respondent is officially graduated from care. Accountability rules, so 7.2301 and 7.2303 connect to, and Welfare and Institution Code 5979 deal with the accountability provisions. So there are provisions both for accountability for the respondent and for the county agency or local government agency if one's been joined. And for respondent, what that entails is if at any point they are found to be not participating, they may be terminated. If they do have a care plan that is ordered and are found to have received all of their services within a timely basis, and are found to have failed that plan, that information shall be considered if the person ends up in a LPS hearing within the next 6 months, with a presumption that the respondent needs additional services. If the county is found to be not providing the services that are required within the care plan or not complying with orders, there is a process by which the court will serve as order to show cause. The care court judge will refer it to the presiding judge or their designee. Then there'll be an order to show cause and a hearing to determine whether or not sanctions are appropriate. In those cases, the respondent and their counsel are entitled to be present and participate. And since it's timely, if the respondent fails to complete the plan, how is the presumption communicated to the LPS court? And that's a good question. It would presumably be within the county behavioral health responsibility to provide that information. I want to add a few things up since this is a training for counsel, a few things to keep in mind. SB 35 added this language here to the definition of counsel. Representation of respondent in these matters does not alter counsel's obligations under the State Bar Act and the rules of professional conduct, including subdivision E of section 6068 of the Business and Professions Code and rule 1.6 of the rules of professional conduct. And this is not a ethics training, but we did include some information on diminished capacity for you folks that may be new to that and the ethical obligations. It's something to look into. There are trainings. In terms, other things to think about is because some of the, particularly for the respondent counsel, if they've been referred from another court, they may also have appointed counsel from another court. That's something to maybe talk to your clients about, may need a release, but to try to connect with what other services there are available. And SB 35 also added this language to 5975.1b. And this gets to, I think there was a question earlier about can an attorney file, and an attorney can file on behalf of a client as long as the petitioner is an eligible petitioner. And Care 100 has a space for the attorney to sign as well. But the note being, if a person other than the respondent files a petition for the CARE Act proceedings or gain an advantage over the respondent in another legal proceeding, then notwithstanding any other provision in this part, it is cause for suspension, disbarment, or other discipline if a member of the state bar is found to have filed the petition or assisted in filing the petition with knowledge that the filing was made in order to gain that advantage. So don't file a petition if you just to help in another legal case, but they do exempt other cases here. So other LPS type cases and dependency cases. And in response to Will's question, the privacy protections, there are some exceptions for other LPS. It's an exception to some of the privacy considerations. All right. Oh, and here's just general things around ethical obligations of a lawyer for a client with diminished capacity. And I think, next slide, we're at the questions. So I know we've had some good questions in here.
At the beginning, there was a question, when serving documents electronically, is it deemed served that same day?
There's no specific rules for CARE Act, so it would be whatever it is in the rest of your cases.
And the next one is, so the petition is filed and the court promptly reviews. How soon is promptly?
It's not defined. But I think most people would say within 2 or 3 days, certainly.
And when applicable, the court refers to the case of BH for investigation and report. When is that?
It would be referred to behavioral health if it's a non-behavioral or county agency, that usually behavioral health. If it's a non-behavioral health petitioner, and they would have to do a report. So that it would be applicable if it met prima facie and it was a non-county behavioral health petitioner, if I understand the question.
And when does PD or another attorney get initial papers?
They should get it at the time of the prima facie determination. At that point, the court will make an order appointing them. And this highlight this because there's been a little bit of confusion, regardless of whether the petitioner is behavioral health or non-behavioral health. If it's yes on the is or maybe a person within 5972, the court will make an order appointing counsel, and at that point they will send, and that will include the petition packet.
And when does PD get the county behavioral reports?
I believe they're all, well, if there's a report at the time, well, there wouldn't be a report, but I think is it 5 days before the hearing?
It is 5 days, I think, for everyone, right? 5 days prior to the hearing, they are required to file it and provide it to the responder and to all the parties basically that are required to receive it.
Next. What evidentiary rules apply at the hearings? Hearsay allowed?
All regular, normal evidentiary rules apply. Although people are allowed to make as we said, the original petitioner is allowed to make a statement, but at the evidentiary hearings, the standard rules of evidence apply. That email there, care.act@jud.ca.gov, goes to all of us. So if you have other questions, you're always welcome to email there, as well as our adult civil mental health page, which has public information on the CARE Act. But thank you for bearing with us. I know that was a lot of information in a short time.
Thank you, everyone.